Hey everyone, so I'm just going to very quickly go over the legal studies exam of last year, and I'm just going to quickly take you through the structure of the book and just go through how you should be viewing these questions as you're doing practice exams leading up to your exam in November, but as well as how you should be revising as well. Now, I'm saying I'm going to do this quickly, but if you know me, this is probably going to take us 20 to 30 minutes. So let's just quickly get started. So this was the front page of the 2018 exam, and it just tells, the date, the reading time, 15 minutes, and your writing time is 2 hours. That's just what we always get, and we know this by now. Now, I'm going to just draw your attention to two things. The first thing is Section A has 7 questions and it's worth 40 marks. Section B has 3 questions and it's also worth 40 marks. So you need to be aware that Section A and B are evenly weighted, although there are more questions. What that essentially means is in Section B, you're going to have a question that's like 1A, B, C, D, E. Right? Whereas in Section A, there's going to be a little bit more of a variety where they're trying to kind of assess some other questions and skills as well. So let's just quickly get into this. Very first thing, there are 2 sections. These are your instructions for Section A with all of your exams, okay? Every single one of them. You will have instructions. For example, in English, for argument analysis, it will give you background information and instructions to begin with. You read that because it leads your response. So you need to read the instructions for Section A and Section B as well. Because what you're going to realize is there's a bit of a difference. Section B is a lot longer than Section A because all Section A says is answer all questions in the spaces provided. So it's not telling you to really link to anything. It's just saying answer them. For example, question 1, 2 marks. Outline one responsibility of a jury in a criminal trial. Now already it says 1. Okay. Now it's very important that you guys are becoming aware of this because it's put it in bold for a reason. It wants 1 responsibility of a jury. Not 2, not 3, but 1. It's 2 marks, right? So don't waste your time telling me a jury can do this, it can do this, it can do this. We don't care. We want your first response. It's a low marker. Grab your marks and go. Okay? You should not be spending, I don't want to give you time allocations, but a minute for this max, right? Just go through it as quickly as you can for a question like that. Here we've got stimulus, very different. Look at question 1, everybody can answer this. Question 2, we're given stimulus material. So we look at this. Kai is in a dispute with his landlord. The landlord refuses to repair the pipes in the bathroom and has declined Kai's request to meet to resolve the matter. Kai has been advised that Consumer Affairs Victoria is the most appropriate body to resolve this dispute. Explain one reason why CAV may not be the most appropriate body to resolve this dispute. Now, what's really important that you guys understand about this, again, see how the word one reason, essentially, and not be, these are put in bold. There's a reason because it wants you to give us one reason why CAV's not appropriate, right? Don't go and give us 3 reasons. Don't interpret that as I need to give 3 reasons why it isn't. No, it's asking, give us 1 reason why it may not be the appropriate body and link back to the case study, right? Kai should be leading your responses, not anything else, okay? So this is how you pick up those type of marks. Now, what I'm usually finding throughout your SACs and throughout your practice exam is that in a situation like this, you do lead by Kai or you do lead by whoever's name that's in because it's right in front of you. It's a low marker. You can apply the question to the stimulus material, right? So that's fine. Let's now jump to question 3. Here we don't have any stimulus material and it's just quickly telling you describe the relationship between treaties and external affairs powers. Straight to the point, done, right? Question 4, now this is where we see a bit of an A and a B situation. So it goes, identify 2 rights of victims in the Victorian criminal justice system, and then explain how the rights identified in Part A aim to uphold the principle of access. Now, I just really want to just mention something before I go on. see how this question has specifically told you to link back to access. Okay, now, two things very, very quickly. This question does not want you to start off by saying, the three principles of justice are fairness, equality, and access. Access is blah, 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 blah. Okay? Equality is this. Fairness is this. Don't waste your time on that. It doesn't want it. It wants you to explain how the two rights that you've identified here uphold access. Now, remember, access can be physical. Access can be mental. Right? So tell me about it. Is it physically allowing them to have access to the courtroom? Right? Or is it mentally helping them? These two are very different things. And when I think of access, I want you to think of it in this term. Okay? There's physical access and there's mental access. Which one? And make sure that your responses revolve around these two. So, whoops, the Richmond Tigers have won. Boo-hoo. So, next, we have question 5. Kylie is a professional sports person. She has commenced a civil proceeding in the Supreme Court of Victoria against her former agent for a breach of contract. The former agent has engaged legal practitioners to defend the claim. Now, already, you should be able to identify a few things. Kylie is our plaintiff. The former agent is the defendant. Okay, she has commenced a civil proceeding. That means the burden's on her. Civil proceedings, balance of probabilities. Done. As you're reading these, you should be doing this in your head. Now look at that. Who has the burden of proof is Kylie's case, and what is the standard of proof? You've already identified that. Right? Done. Describe one responsibility of the legal practitioners for Kylie's former agent at trial if Kylie's case goes to trial. Now already, right, let's go through this. One responsibility is in bold, so it wants one thing. Legal practitioners of Kylie's former agent. Kylie's former agent is the defendant, okay? So they want to know, what is the defendant's lawyers going to do if it goes to trial, right? So again, thinking critically here, it doesn't want to know what Kylie's lawyers are going to do. It's asking you, what is the defendant's lawyers going to do, right? Describe one responsibility that they have. Now, next question is C, which means it's attached to this. Now, can you see how in question 5, right, Kylie's name is kind of littered throughout A and B. It's quite obvious and it's right there for you. So as you're reading, you'll mentally make those links. But with question C, Kylie's name is not here. This is very important for you to notice, because I want you to remember this isn't, for example, that's question 5. This is not, this isn't question 6. That is not the case. This is question 5, which means you need to lead by Kylie. Right? So explain one way in which the judge's use of case management powers in the dispute could achieve the principle of fairness. So remember in the previous question how they wanted access? Here they've specifically said fairness again. So this, again, what I mean by that is they're specifically telling you link to this. Don't link to all three of them. We don't really care about that. We want you to tell us, for example, how does the power to order mediation uphold fairness? And remember to mention her name and her former agent. That's the defendant. Okay? So just doing things like that, just remembering, because otherwise this is going to become a very rote-based answer. Otherwise you can go, judges have the power to order mediation. This is when the plaintiff and the defendant must try to resolve their dispute outside of court in order to, reduce costs and have an out-of-court settlement. That is so rote-based, right? It's not telling us anything. But starting off in a way, for example, where you say, the judge, she has commenced in the Supreme Court. The judge in the Supreme Court has the power to order mediation. This means the judge may request that Kylie and her former agent attend mediation and try to resolve their dispute of a breach of contract outside of court and to come to a mutual agreement. Something like that, and then linking it back to fairness is going to get you that last mark, right? See the difference in those two responses that I've just given you. One's very rote-based and the other one is a clear example of, I know that this is what the question is about and I'm going to apply it. So from memory, this should be the, second last question, yeah. So I'm going to quickly go through this one as well. Question 6, evaluate 2 ways in which the Australian Constitution enables the Australian people to act as a check on Parliament in lawmaking. Again, I remember when this was happening last year, a lot of kids did not take this or realise that it was referring to Australian people having a check. For example, a referendum is a very good way of discussing it because of section 128. The task word evaluate is very important, and here it says 2 ways in bold. So that's one way that we've identified. Then you have your choice in your second way. Evaluate, look at the pros and the cons. If there's 2, those over there, you can kind of get where the 8 marks are at. There's no case study here, so this is again where you would maybe potentially use case studies here, based on the ones that you've identified to see how they can act as a check on Parliament in lawmaking. So I'm going to quickly move on. Question 7, the 10 marker. The best way for individuals to influence lawmakers to reform the Victorian civil justice system is to appeal cases. Now, automatically, I'm looking at this and I'm going, all right, Unit 4 AOS 2, because individuals influence lawmakers appeal cases. Now, as you know, there are 3 ways that people can influence law reform. Okay, the first one is, according to the study design, we had petitions, we had demonstrations, and we had the use of courts. Now, already this question is actually referring and it's saying this is the best way because the use of courts is appealing cases. Petitions and demonstrations aren't that. And then in the question, let's have a look. Discuss the extent to which you agree with this statement. In your answer, explain how one recommended reform to the civil justice system may assist in achieving justice. Right? This was a question where initially, remember we did this one in class together, this was very confronting because you read that and you go, oh my God, what do they want? So if you say, for example, appealing cases is not the best way, the use of the courts are, well, you haven't been able to make that link between this and what this actually is. So I will go more into depth with how you would tackle a response like this in another video, but just for today, just wanted to show you how, looking at the wording of it, it kind of gives you a bit of a hint about how they want you to respond. Now, I'm going to quickly move on to what I initially needed to talk to you about and why I made this video to begin with. Okay, took me a while, but we're here now. Section B, we're here. So, this is what is important for you to look at. This entire box right here. It says, use stimulus material where provided to answer the questions in this section. It is not intended that this material will provide you with all the information to fully answer the questions. It's essentially saying use this information in all of your responses. You need to link back. Section B, put it into your minds that when you go into your exam, when you are doing practice exams, it's one where you need to refer to stimulus. And I'm going to show you why this is tricky and why we need to remind ourselves to do this. Over here, it's quite simple, right? Remember how last time I was looking at where they were putting people's names? So here they've got Bob is there and we've got Ada is there, right? Ada wants to sue Bob. Advise Ada on one enforcement issue that she should consider before initiating this claim. The question's told you. It's leading by the person. and you will naturally respond to that, right? One enforcement issue that ADA should consider, whatever it is, and you'll get to it. The issues more so come as we go throughout this. Question B, distinguish between mitigating and aggravating factors to be considered in sentencing and provide an example of each in Bob's case. Mitigating factors and aggravating factors. We know these. Aggravating makes things more serious. Mitigating kind of brings them down a little bit. And provide an example of each in Bob's case. Again, it's kind of there, right? You should be leading by the case study. Look at the marks over here. Distinguish, tell me the difference between them. Probably tell me what they are. They are, both mitigating and aggravating factors are things that a judge must take into consideration when sentencing an offender that's either being found guilty or has pleaded guilty. In Bob's case, and then you'd go through here and you'd kind of find out what they are. Here, this is where a lot of people will forget to link back, because the question, right, and if we think about it logistically, this will be on a separate page in the fact that you won't see it, and because Bob's name or any of the individuals' names not here, you will forget to do that. See how here it says, in this case. That's a small clue that VCAR's given you to remind you, hey, you need to make sure that you're linking back to Bob being charged with 4 offences, for example, right? So you need to make sure in this question, okay, if you do not link plea negotiations back to Bob, and back to the situation that was provided to you, you will not gain full marks at all. So what I would recommend is, in section B, for a lot of your answers, if you can, try to actually start off by using their names, okay? Don't give me hypothetical scenarios about why it may or may not be appropriate to have a plea negotiation, right? You need to take into consideration certain things. You need to take into consideration with them the defendant, the victim, the community, right? This, from memory, this case was in a public space. Where was it? Pretty sure it was in a public place from memory, right? So you need to take those things into consideration. You also need to take into consideration the prosecution. All these things need to come in, but you need to link these back to the actual case study, the information that's provided to you on this page over here, okay? So let's continue. D, discuss the ability of imprisonment to both deter Bob and protect the community if Bob is found guilty and sentenced to a term in prison. Now, although marks-wise, this was 5 marks and this is 6 marks, see how in this question they're kind of reminding you to talk about the case material, right? So remember, D, C, B, and A. They all link to question 1. Question 1 is a total of 17 marks. So remember to link back to those. Question 2. Honestly, I feel like this is where we will have a lot of this, I won't say difficulties, but we will have the biggest barrier of linking back to the stimulus. So I remember when everyone saw these, all these memes kind of went around about tanning units, what they meant, and all that sort of stuff, as they always do with exams. So question 2 is worth 13 marks, right? So if we kind of go through it, you've got an A, you've got a B, you've got a C, you've got a D, and that's really about it. So we go here. This is, again, reading time. That 15 minutes is so crucial that you take, that you use it seriously. Please do not sit there with your arms crossed waiting, okay? You need to be reading these things. Read it 3-4 times if you have to understand. So tanning units, also known as solariums or tanning beds, are machines used to artificially tan skin through the use of ultraviolet radiation. In 2007, the ABC broadcasted a program titled The Dangers of a Deadly Tan. The program considered the increase in the use of tanning beds in Victoria and the possible connection between tanning units and melanoma, a form of cancer. Amendments were made to the Radiation Act, which came into effect on the 1st of January 2015. It then became an offence for a person to operate a business allowing the use of a tanning unit. It remains legal to own a solarium bed for personal use only. So this is the extract that we're looking at now. So if I just highlight source 1, we have the following is an extract of Section 3 from Definitions of the Radiation Act. The tanning unit means are electrically powered radiation apparatus designed to produce tanning of the human skin by utilizing ultraviolet radiation. So they're giving you a definition essentially. It doesn't really give us much insight, but the definition's there. So you can't say, oh, they should tell us what, tanning unit means. They kind of have. The following is an extract from the Radiation Act, which was inserted where the Act was amended. So 23D says, offence to conduct a commercial tanning practice. So commercial means business, right? We know this. A person must not provide or offer to provide for fee or reward the use of a tanning unit or operate or offer to operate for fee or reward a tanning unit. Penalty in the case of a natural person, 60 penalty units, and in the case of a body corporate, 300 penalty units. Then we have source 3 over here. So you've been given 3 sources, which, hey, you're probably going to have to draw on all 3 in one case. It's criminal. It should be stopped. Melanoma survivor issues warning on illegal solariums. Underground solariums are being advertised online across Australia more than 2 years after the commercial use of tanning beds was banned nationally. While it is legal to own a solarium for personal use since 2005, it has been illegal for tanning beds to be used anywhere that charges a fee. All right, so we've got 3 different things, right? We have a definition in source 1. We have what's been added in, right? How it's an issue. And then we have someone's response to it. That's not really an effective law, essentially, because, people are advertising it online, right? So we're just looking at this, trying to take all this in. This is 1 page of stimulus material. See how here, for example, it wasn't even half a page, it was a quarter of a page, right? See how that's a quarter of a page? Here, it's a full page of stimulus. That's how I want you to view it, okay? It's a full page. It is a lot to read. So, let's go through. Outline 1 role of the media in changing law. Now, you know how we were looking at this before? What stood out to me was, and I've underlined it here, which is the ABC had broadcast a program called The Dangers of a Deadly Tan. So the use of media, traditional media in this case, got a message out. It was saying that this is what it's doing and it's causing cancer. You need to make that link back to the case study by referencing ABC. And even, wouldn't hurt you, dangers of a deadly tan. Stimulus-based. Describe 1 reason, look how it's in bold, why a court may need to interpret the phrase tanning unit in Section 23D of the Radiation Act. So this is when we go back and I go, okay, 23D. So what we are quite lucky in this sense is that it's actually forcing you. It's saying, hey, go back to the stimulus material. Go back here. So I go back to 23D and I look at it and I'm like, all right, where does it, for example, say tanning unit? That's the phrase. So I look here and I'm like, all right, tanning unit's there and tanning unit's there. Why would a court need to interpret that? And I go, wait a second, up here, they had a definition of tanning unit. So I can't say that the court may need to interpret tanning unit because the definition may be, there's no definition or whatever it is. It's actually given to us. The definition is there. This is where you need to think very, very critically. See how I've underlined 2 things, apparatus and ultraviolet radiation. I underlined those because as I was reading it in my head, I was like, what's an apparatus? What's an ultraviolet radiation? I didn't make it clear when I underlined it that I wasn't too sure what it meant, but that was my way of saying, what does that actually mean? And bingo, that is allowing me to answer this question. A reason why a court may need to interpret the phrase tanning unit in Section 23D is because the definition of tanning unit in Section 3 of the Radiation Act 2005 contains words that may be ambiguous or hard to define. For example, the term apparatus or ultraviolet radiation. If you don't know what it means, that's good. Use that. Use that as a way of saying, if I don't know what it means, course probably going to need to interpret it. Okay? So again, see how this question, it's only worth 3 marks, but those 3 marks required me to look into sources 1 and source 2. Right? Again, applying. Technically speaking, that question only forces me to look at this. But it's my way of linking tanning unit to the previous one and finding the definition that's allowing me to go, this question doesn't want me to look at this. It actually wants me to look at that. But saying source 1 is going to be way too easy, right? So you got to think critically. Again, in the moment, it's hard to do these things. In that moment, that is why those 15 minutes are so important. Right? It is so important that you read through them, because the next time you read through, because when you're doing the question again, you'll read through all of this again, right? But it's your second time reading it, not your first. So you're kind of going to remember what those things were. Then we've got C, explain the link between the use of tanning units and the need for law reform. Again, this needs to be stimulus driven. Right, so I've taken up too much of your time on this question. I'm going to quickly move on. D, if the Commonwealth Parliament were to pass legislation allowing the commercial use of tanning units, how might Section 109 of the Australian Constitution be relevant? We've gone over Section 109 so many times, and I'm so proud of all of you, because in your responses, every one of you say that, it's to the state of inconsistency, it's not the whole thing. And the most important thing is, right, 2 laws, right, a state law and a Commonwealth law that's made in concurrent areas may be operating at the exact same time, and they may be the complete opposite things, right? They will continue to run like that until someone challenges it and takes it to the High Court. Section 109 does not automatically come into play. Right? So you can have 2 things existing in conflict for 10 years. If no one's actually going to go to the High Court, which we know that there are certain factors which prohibit people from doing that, if they don't do that, then it's going to kind of stay the way it is. Right? So I'm just going to quickly move on now. Section 109, we're all kind of good with that. Now, question 3. Now, from memory, this is the last one. This is our last question in the paper. Right? So it's 10 marks. Whoops, it's 10 marks. Where are these 10 marks? So I've got an A that's worth 4. I've got a B that's worth 6. So let's go through this. On the 18th of June 2018, Australian Green Senator Jordan Steele John introduced a bill into the Senate. The bill, the Commonwealth Electoral Amendment Lowering Voting Age and Increasing Voter Participation Bill 2018, aims to amend the law to allow 16-17-year-olds to vote in federal elections. The following data is from the Senate official Hansard on the 18th of June 2018. Now, this is important because a few things have been given to us. Now, initially, you need to kind of have some understanding of politics, and, Unit 4 AOS2 kind of does that for you, where you kind of look at, you've got the Liberals, the Coalition, you've got Labor, and you kind of have a bit of an understanding about how the Australian political parties are basically formed and like who's where and all that sort of stuff. Now, Greens, okay, I'm going to go here. We've got the Greens. This guy is from the Greens. I look here, and look, they even said his name, 9, okay? So 9 Greens are in the Senate. Then I look at some other things. I'm like, all right, who else do I have over here? We've got the Liberal National, 31. The Australian Labor Party, over here, the opposition, we've got 26 there. And we've got 10 independents. Now, what we need to do is, right, we need to look at the number of people in the Senate, and the question is being nice enough to tell that it's 76, right? So 76 divided by 2 is 38, but we don't need 50%, we need 50 plus 1. So in order to pass a bill, we are going to need 39 votes, right? So keep that in the back of your mind. Now, looking at the Greens and looking at that, chances are they're going to need to get 30 more people to agree with them. And just looking at this composition, that's going to be a little bit challenging, right? Not impossible. It's going to be a little bit challenging. Maybe if the Greens start negotiating with people, they'll end up watering down, the electoral amendment bill, which kind of, will cater for other people, but it might kind of take away from what they initially wanted to do. Anyways, I'm going a bit of a rant here. Let's actually go to the question. Explain how a parliamentary committee or a royal commission could influence law reform to allow 16, 17-year-olds to vote in the federal election. So at our school, we focus on parliamentary committees, not a royal commission, right? So what does a parliamentary committee do? Right? You kind of have to go back and you need to find out, what are they? How do they operate? And then link back to influence law reform. Okay? Again, in terms of the amount of stimulus we've been given, we've only been given a quarter. Compared to question 2 where we had a full page for the tanning units, this isn't really that much, right? So we need to link back. And again, the question has kind of gone on you to do that for you by adding in influence law reform to allow 16 and 17-year-olds to vote. So let's look at the very last question here, which is discuss the ability of the Commonwealth Parliament to change the law to allow 16 to 17-year-olds to vote in the federal elections. Now, initially, when you look at this question, you might be like, whoa, what does this question want me to talk about? When you're in doubt in situations like this, or just in anything in general in section B, just go back to the stimulus, okay? The question wants the ability of the Commonwealth Parliament to change it. I'm looking at this and I'm like, all right, to change it. I've already done some maths beforehand. 39 votes. The guy and his party only have 9. Labor's got 26. Liberal National Coalition have 31, right? And we've got 10 independents. Traditionally, not even traditionally, right? If all 26 of Labor, because typically, Labor and the Greens kind of do help each other out every now and then, even if these two kind of combine together, they will have 35 votes, right? It's not enough for our 39. So we need to think, okay, what has to happen? Well, here, the Green senator needs to negotiate and talk with these people, as well as these people and these people. It's not guaranteed. Maybe out of the 26, only 3 or 4 of them. So we can't just assume that every single Labor person is going to support the Greens, or every single Greens person will support Labor. This is when we're going to need to start thinking very, very critically about it. So discuss the ability of the Commonwealth Parliament to change the law to allow 16, 17-year-olds to vote. Well, in this case, it's going to be quite difficult, just based on the Senate composition, right? Based on the Senate's composition. And you need to take into consideration that these people need to represent the views of their state, right? The Senate's also kind of known as the state's house. So again, with this type of question, it all needs to come back to this and your interpretation of data, and having some understanding about, okay, well, how is this going to work? And, how it might not. The question isn't really asking you, is this a hostile Senate, a rubber stamp Senate, or whatever that type of thing is. It's actually just saying, what are the chances, or what's the ability for this law to actually pass? And while obviously, a law can pass, even if you only have 9, because if a lot of people agree with you, they might pass it. It just requires Senator Jordan Steele John to basically negotiate with a lot of people. And, that might be good for us because, it's forcing people to get them on board. It's saying, hey, what would you like for me to add into, for you to agree with this amendment? And that's going to force people to, be a little bit more active when passing bills. Yes, it may lead to the actual bill being watered down, which might not be exactly what they wanted, but it's a way of ensuring that laws aren't just passing left, right, and centre, right? If something wants to change, you need to really, really think about it. You need to negotiate, because this is a whole thing. It's the Commonwealth Parliament. You're not just making laws for yourself, you're making it for the whole nation. And that was a 6 marker. So that brings us to the end of the exam, right? This is your extra space and whatnot. So that's it, right? I'm hoping that this has kind of been helpful for you guys, just in relation to how you should be responding to the exam. I think from mine, the one thing that I really, really want you to take away from this is stimulus is very important, and linking back, right? Please, please remember to link back, because there is nothing worse than, you losing, out of the 40 marks, right? I don't want people losing 12 marks because they didn't link back to the stimulus. So please remember, always link back, and especially with section B. When we're in class, I'll go through the CPAP exam with you guys, because I found that linking back became a little bit of a concern for some of us. And yeah, enjoy your holidays, and I'll